to offer bouquet to Shri Anil R. Dave. Bhavya Bhai. I would now request Shri Arvind Datar sir for his address. Datar sir, I would request you for the address, please.
Good afternoon, everybody. Since we are late, I'll cut short the introductory formalities. Just to thank Justice Ujjwal Bhuyan for taking the trouble of coming here and staying back to listen to us. I must thank Justice Anil Dave for inviting me here to Junagadh, and I'm really overwhelmed with the hospitality of Mr. Samir Jani and the entire team here. I have a long association with the All India Federation of Taxpayers. I think in the late 80s, I spoke at Jamshedpur as a young junior when my excise book had just been published. And I've also spoken at other seminars at Hyderabad and other places. This is really a special occasion for me. I got to meet so many people after so many years. And one important thing was, while we were flying down from Chennai to Bombay to Rajkot, my wife suddenly noticed on the Google that there is Datar Hills in Junagadh. You know, I used to always, as a child, I used to pass by roads and I used to say, can there be a Datar lane or a Datar road or something like that? But now I've got Datar Hills. So I can't wait to tell my granddaughters this. I'm also thankful to Mr. Samir Jani for calling me as Amitabh Bachchan. This is really, really... But it's nice to be in the presence of so many dons of the legal profession. Yes. Now, today, in a sense, is significant because we are just 17 days away from the end of the year, end of the month, end of the year, and end of perhaps the last year of the first quarter of the 21st century. 2025, we begin the journey for the next quarter. If you see the economic data, there are some very healthy positive signs. We have a direct tax collection of 23.5 lakh crores. We have an indirect tax collection of 14.95 crores. Despite slowdown in Europe, the US, China also, we are still having a rate of 5.5 to 6% GDP, which is good. It can be better, but it is good. So these are all positive signs as we enter the new year. But I thought that it is always better to take a 30,000-foot view and have an overall perspective of where we are, where we were, and where we could possibly be. And I'll just share a few data points before I come to my talk on the current controversial issues. In 2000, the Fortune 500 global listing, I always follow that very carefully. In the Fortune 500 listing of 2000, that is just at the beginning of this century, China had 19 companies in the Fortune 500. India had 7. In 2023, China has 135 companies in the first 500. India continues to have 7. Our GDP has grown. It was 0.5 trillion. It has now become 2.33 trillion. China has gone to 14 trillion. Per capita income, they have gone up by 13.5 times. We have gone up by 6 times. So all this is time for contemplation. All this is time for reflection. Where are we? Why aren't we progressed so much? what is the main problem. And that brings me to this session, which is involving tax practitioners. And after finishing almost 45 years in the legal profession, and most of my life has been in tax, I've had the opportunity of interacting with domestic large companies, small companies, multinationals, and I can say honestly that the single largest deterrent for our economic growth is our tax laws and our tax administration. And I say this with responsibility. Why is the investment climate, why is the soil of India not fertile for more and more investments? I have personally witnessed people who have come here, put up a plant, got put off, and then shifted to Vietnam, shifted to Bangladesh in textiles, shifted to other countries. So this really calls for a great introspection. Just give one example, because time is short, so I've cut short my presentation a bit. I was dealing with one of the largest automobile manufacturers in the US. They've got a matter in Europe. They've got some matters in the Supreme Court. And while having the conference, they have got multiple litigations, customs, income tax, transfer pricing, so on and so forth. So I was speaking to the CFO who had come down from Europe, and he told me something very disturbing. He said, you know, Mr. Datar, India has 1.9% of our global sales, but we have 94% of our global litigation is in India. Two weeks ago, an outstanding civil servant, Mr. Sanjay Malhotra, who is now our RBI governor, he was a revenue secretary. And he made a very important statement which all of us must take to heart. He told the tax officers, please don't kill the golden goose. Please don't make exaggerated demands and kill the golden goose. And this is the point I wanted to highlight. And I have borne witness to this. In the early 2000s, the new telecom policy came. The new telecom policy shifted in 99, and the new telecom policy came. The then disinvestment minister, Mr. Arun Shourie, was able to persuade a large European manufacturer not to go to China, but to come to Madras. They put up a plant in a SEZ, and over the years, they exported 27,000 crores of mobile phones, chargers and accessories. One fine day in February, a Assistant Commissioner of Sales Tax asked them some particulars. He said, give me the list of all your exports. So they said, sir, as per our computer, we got 1,18,000 bills of lading over the last 6 years. We can't give everything, we'll give a sample. He said SSC is not cooperating and raised a demand of 25,600 crores by treating all the export sales for the last 6 years as interstate sales. He then said all these sales have been made without C-form and therefore I'm levying 12% tax. Eventually the company closed down. We went to the writ court, a long litigation, but ultimately the company closed down. The golden goose was killed. And let me tell you, ladies and gentlemen, if you take the data, it is very, very unlikely that many other companies from that country or that area have invested in India. This is the problem which I mentioned. Now, coming to the current controversial issues, since time is short, I've just divided this into two parts. One is the direct taxes and one is the indirect taxes. Now, as far as current controversial tax issues are concerned, I'm going to say what are actually the controversies. I'm just taking 2-3 points from direct taxes, 2-3 points from indirect taxes, and then I'll move on because there are no more speakers after me. There is an announcement that there's going to be a direct taxes code 2025. For the life of me, I do not know what is this logic in having new laws. In 2007-2008, the then finance minister, Mr. Pranab Mukherjee, said that they want to have a complete relook at the tax system. They formed a committee and they decided to frame the direct taxes code bill. It got delayed by 2 years, and finally the Direct Taxes Code Bill 2010 was introduced in Parliament. And please see the relevant ITR. The statement of objects and reasons of that bill is very interesting. Very interesting. The bill says the Income Tax Act has now completed more than almost 60 years. It has become very complex. Even chartered accountants and administrators are finding it difficult to understand it. Therefore, we must simplify the law. And they've introduced the Direct Taxes Bill. Now, at that time, we just had the opportunity of revising Kanga and Palkhiwala's next edition, and I had gone through the bill. And I found that in the name of simplification, the old Income Tax Act had about 350 sections and 14 schedules, whereas the new law had 315 sections, 22 schedules. The definition section had 297 definitions. So my thing is, Companies Act 56 became Companies Act 2013. You had various reforms. You had recently the Evidence Act, the Criminal Procedure Code, IPC all replaced. But my only request is, and through the forum also, once the bill is going to be, this new draft is going to come and give discussions. If you're not going to change the basic structure of the Income Tax Act, if you're not going to change salary, capital gains, house property, there is no point in simply reorganizing the sections. You're not going to solve the problem at all. So depending on what the bill comes, this federation can also put their suggestions, and I would rather feel that let the old act continue, live with it. The problem is not with the act, the problem with its administration. The second point, and I'll tell you one thing, my senior was a leading tax practitioner. Actually, I must just give you an interesting example. There's a wonderful Hamlin lecture by a great Australian judge, Michael Kirby. He said if a foreigner comes to England, who was actually from 1875, he comes to England, he will find everything has changed. The roads are different, the taxis are different, the automation. The only thing which has not changed are the English courts. You still have the same wigs and the same atmosphere and so on. So this question of tax simplification has continued ever since I joined the bar in the early 80s. And my senior once told me, he says, look, you cannot have a simplified tax law. A simple tax law is an oxymoron. You cannot have it. Because even if the law is simple, lawyers and chartered accountants will make it complicated in 2 to 3 years. So don't expect a simple tax law. The only exception I'll tell you as a simple tax law is what is called the flat tax system, which is adopted in 17 countries. Where what they say is, whatever is your income, gross income, you pay 11% flat. So there is no deduction, no discussion, nothing. So if you have a flat tax system, then you can have simplified law. But if you have a complex system, then you will have always a complicated tax law. And my senior gave the example of Newtonian law of physics. He said, what is simple will have large number of leakages. If you want to have a system which does not have leakages, then you will necessarily have complex system which will take care of all possible areas of evasion. So I think we should put an end to this Direct Tax Code 2025, but it will come, and I hope that we are able to do something about it. The second point I want to make in direct taxes is, we should seriously relook at this faceless assessment and faceless appeals. Justice Bhuyan mentioned about 5 lakh appeals pending in the Commissioner Appeals. Our committee has made a suggestion that if the income of the assessee is more than 1 crore, then don't have faceless assessment, give it a chance of opening. Today what is happening is, if you take the income tax ITR 6th form, it has got more than 70, 80 entries. Now how do you explain to an officer complex situations through faceless? And I have really pleaded that if you want to have faceless assessment for small assessees, please do so. But please, please do not have faceless appeals. It's a quasi-judicial function. Just imagine if you're in any court and you're just arguing and you can't see the judge, you can't at all put your thing. So the second point I wanted to mention was, the faceless appeal should be abolished, and let us have faceless assessment for small assessees. The third controversy I would like to suggest, see, ultimately any tax is going to lead to dispute. It is an eternal tussle between, as Lord Green put it, it is a tussle between the taxpayer and the revenue. And in many cases, ultimately, it is a tug of war. If the assessee wins, there is a change in the law. If the SSE loses, there is other problems, but disputes are going to be there wherever there is a tax system. The most important point in a tax system is how efficient is your adjudication mechanism. Now, ever since I have joined the bar, more than 4 decades, I have not seen a single reassessment notice dropped in my entire life. Once a notice is issued, it will take its course. You only get relief in the CIT appeals or in the tribunal. And I'll give an example. I've been doing a lot of indirect taxes. In my entire life, only one excise case was dropped where the refund was 48,000 rupees. I was a raw junior and we got a refund of 48,000 rupees. The name of the party was Sabina Cleaning Powder. I still remember the name of the SSC. It was one unique case. Even that money we did not get. Then there was a public grievance committee set up. I went and appeared to the commissioner and we got that 48,000 rupees refund. So now the point is we require good appellate mechanism. And I've been fighting this battle for tribunals. The most deleterious thing which has happened is appointing members for 4 years at a time. We have pleaded to the Supreme Court that at least for large tax tribunals, the GST tribunal or the excise tribunal or the income tax tribunal, you recruit young people at the age of 40, 45 and let them take it as a career option and go until 62. There are a large number of lawyers who would like to exercise, who would like to take a career in the judicial path. They may not become high court judges, but being a tribunal member is also exercising judicial functions. So I have been pleading, the committee has been pleading, that let us go back to the old system and let us have income tax tribunals with the retirement age is 62 years. I can tell you from experience, one of my happiest moments in my young days was appearing before the income tax tribunal. We had people like TNC Ragarajan, Justice Ranganathan was there. So many eminent people were there in the tribunal. It was literally like appearing before a high court or a Supreme Court, the judicial approach, and I'm looking forward to those glorious days again. The other point I'd like to flag to this audience is, if you want foreign direct investment, it is most important to have a proper authority for advance ruling. An independent authority for advance ruling is the need of the hour. This has been repeatedly told to me by various clients, foreign clients, who say that, look, we can deal with anything. You tell me my tax is 40%, I will live with it. You tell me that my approval will take 6 months, I will deal with it. But I want certainty. I don't want to be in the realm of uncertainty. So if I'm going to invest into India, I should know that, look, this is the tax I'm going to pay, and I'll live with it. I'll make my plans accordingly. And we had a wonderful system which was put in 1992, the advance authority ruling. You had Justice Ranganathan, then you had Justice Syed Shah Qadri, you had other eminent judges who were there. And it was such a wonderful mechanism. For some reason, it has been abolished. It is now a board of advance ruling consisting of 2 commissioners. Now, how do you expect 2 commissioners, with all due respect, to give a ruling against their own department when they're serving officers? So one important controversy which we have to sort out is to have an independent board, independent authority of advance ruling. You see, the point is, the whole trouble, as I see as a tax lawyer, looking beyond the day-to-day practice, is what is the philosophy of our tax system? What is the underlying philosophy of our tax system? The underlying philosophy, unfortunately, is revenue maximization rather than growth maximization. Tax is always a byproduct. It cannot be an end in itself. Today, what is happening is you have to keep on focusing on revenue targets regardless of the collateral damage you give. I'll come to this more in GST. The other difficulty, look at how the system works and how unfortunate consequences take place. There was a whole controversy of subsidies. You want to come to Gujarat, invest in a backward area, you will get tax holiday, you will get stamp duty exemptions, you will get provident fund exemptions. Why? Because to invest in that area, your costs are going to be more. You will have to be compensated. That's why you see in all northeast states, other states, there were a large number of tax incentives were given for setting up industries. The matter went to Supreme Court. Is subsidy taxable or not? Supreme Court in a very elaborate judgment said, if the subsidy is capital in nature, for putting up a factory, for substantial expansion, it is capital. But if it is for promoting your profits for a running company, then it is revenue and taxable. So they made a very clear distinction, and the first distinction was made in 1922 in a case regarding a Scotland dockyard. But this was the thing when Supreme Court finally settled it. Now what do? You simply amend the law and say all subsidies are taxable. Not only that, what is worse, it's the matter is pending in the Supreme Court. What is worse is that you now say a company in Maharashtra goes to a backward region. It gets 50% stamp duty waiver for setting up the unit on the stamp duty. Now the waiver of stamp duty is deemed to be your income and taxed. So look at the absurdity. I have not spent the money on stamp duty. I have got some 50% provident fund waiver, but what I have not spent is deemed to be my income and I pay 39% tax. And we demonstrate to the court, the Supreme Court has finally admitted the matter, we demonstrated that I have got total of say 200 crores of subsidies for putting up a large plant in a backward area, but out of every rupee I earn of the subsidy, 39 paise is taken away by tax. Now look at if you study deeply, who gives the subsidy? The state government. It is the state revenue which is state taxpayers' money which is going for the tax purposes, and the central government takes away 39 paise in the rupee, which is completely unfair. I mean, are you promoting economic growth or are you promoting tax collection? That is the point I'm making. Now I come to GST. This is now the big elephant in the room. And believe me, unless there is some curbing, some curtailment of what is going on, we are going to lead to very, very serious problems. Only yesterday, what is happening, I was told at the ground level, is just the focus on collecting more and more as we approach towards March is leading to completely absurd demands. And let's give one example and I'll move on. It's just a live case. It is coming up next week for admission. There is a bank. It's a small bank. It's not a nationalized bank. Now, they charge interest. Now, interest, there is no GST. When a bank earns interest, they give a loan on it, there's no GST. They give some gold loans, and for a person who defaults, there is a penal interest. So the officer took the view, the show cause in the notice, that interest is not liable to GST, but penal interest will be liable to GST. So the bank said, sorry, penal interest is part of the game. It's part of the contract. If you don't pay within so and so time, I'll charge you higher interest. Now look at the best thing what has happened. What the GST has done is, they have taken the total interest income of the bank. The bank has got loans, advances, etc., vehicle loans. Total interest income is taken from the balance sheet by the Tamil Nadu officer, and it is taxed at 18%. The total income. Then that the story doesn't picture baki hai. Then he then goes to the expenditure side, takes the entire expenditure and levies 18% tax on the entire expenditure on reverse charge basis. This is the demand of 2,400 crores on a bank whose annual profit is 349 crores. We've got cases, just then a friend told me that I'm a job worker. I do job work. My total turnover is 11 crores on job work. But what they do is, on some dispute, they say, you've taken a job work and they tax me on the entire job. Like if I'm going to do some welding for a truck, you can charge me on welding charges, you can't charge me on the cost of the truck. So these are the things which are happening as far as GST is concerned. So this is what Justice Mrs. Sanjeev Malhotra warned, because we made a representation that this is happening. Mr. Malhotra said, don't kill the golden goose. Unfortunately, he's gone to the Reserve Bank. I think officers must take heed of it and not try to make these absurd demands. But two more controversial issues on GST. Justice Bhuyan was part of two 9-judge benches which went into the issue of mining and on liquor. So yesterday I was talking to some people and there seems to be some controversy on that. I'll just touch upon it and I'll move on. Take liquor. Now in synthetics and chemicals, the decision was that if it's industrial alcohol, then states have no power to deal with industrial alcohol. It's only a central subject. The whole issue is, what is the meaning of intoxicating liquor? Does intoxicating liquor means liquor which you can drink as such? Or does it have got a much wider connotation which includes all kinds of extra neutral alcohol? Now just to give you a picture of this, you take see, basically liquor will be made from either molasses or from corn, typically. Let's take sugar, for example, molasses. A sugar factory makes molasses, makes sugar. As a byproduct, they have molasses. Molasses can be made into alcohol. Now, rectified spirit is basically removing the impurities and making rectified spirit, which is also called extra neutral alcohol. The highly purified form is extra neutral alcohol. 95% alcohol is ENA. Now, today, in certain states, you can take extra neutral alcohol, dilute it, and have it as a drink, no problems. In fact, the country liquor which is sold is nothing but diluted extra neutral alcohol. You bring it down to 30%, 35%, and then you can sell it. The main issue now is with all the industries, can GST be levied on this item, on this issue, or will it be subject to state laws? Now, my view is this, which I have put forth. Just visualize a factory, right? This is the factory gate. The product leaves the factory at this point, and that's the taxing point. If you're making extra neutral alcohol, which is capable of being converted into liquor, vodka, whiskey, rum, etc., you can make it. It will go to a distillery, which will then convert it into the appropriate alcohol. If that alcohol is going to be sent for industrial purposes, it can't leave the factory unless it is denatured by means of adding denaturant spirits, denaturant chemicals. And there is a rule, if you want it to go for paints, you have to add this denaturant. If you want to do for this, add this denaturant. This denatured alcohol can also be consumed, but it is highly harmful to health. If it contains methyl alcohol, you'll go blind and you'll die. But otherwise, this denatured spirit, we can technically call it, is unfit for human consumption. It should not be consumed. Now, the very simple point is, just there are two things, black and white. If the liquor is going for human consumption, it will be subject to state laws. If it is going for industrial purposes, it is subject to GST, subject to central levies. That's a simple point, and I hope the GST Council clarifies it at the moment. The question is whether extra neutral alcohol can still be subject to state central law as a problem. As far as mines and minerals is concerned, which Mr. Gulati is going to deal with at length, the whole issue is a very important ruling, and I think the Supreme Court bench, where Justice Bhuyan was a party, has emphasized the need for the states to have more autonomy to levy taxes. This judgment has emphasized the importance of fiscal federalism. They said when the state power of taxation is there, it should as far as possible not be interfered with. So if it's entry 49, tax on land and buildings, not subject to any state control, give full freedom to the states. Tax on mineral rights, subject to parliament, yes, but they can tax it. So after the judgment, now one thing that is clarified is royalty is not tax. Royalty is consideration. That is the view taken by the 9-judge bench overruling India Cements. What is the consequence for GST? That's going to be a big issue now. If royalty is consideration and it is not a tax, then can it be subject to tax on GST? If the original argument was, if royalty is a tax, you can't levy GST on this because you can't have tax on tax. But royalty is not a tax, it is consideration. Can you levy GST on that? In my view, the answer is no, because if it is consideration, then levying a tax on royalty is a taxing mineral rights, and that is fully a state subject. So as long as royalty is for mining amounts to consideration, the entire taxation can only be in terms of the state laws, and GST will not have a place. The whole issue, courts will have to decide what is the scope of the non-obstante clause in Article 246A, notwithstanding anything contained. Will that prevail over legislative entries or not? I'm not getting into technicalities, but my view is GST, the only purpose of putting non-obstante clause in Article 246A is to enable concurrent power of taxation. Till GST, taxes could be either by the center or by the state, but not by both. But 246A does not permit GST to be levied on all those items which are mentioned in entry 46 to 53 of the state list. These still continue to be the state subject. So on mining minerals, this is the controversy I wanted to highlight. And the last point which I wanted to mention on GST, which is again a huge problem with foreign clients, foreign investors, is secondment. I don't know how many of you know this burning problem which is affecting large number of, almost every company which has got investment in India. Now take, for example, Maruti, hypothetically. It is, I think 52% is owned by Suzuki. And they will send employees to India to work here. Take Hyundai, which is based in Chennai. At any given point of time, there are more than 120 Korean engineers, professionals working in India, in Madras. Now, somebody took the view that these employees are coming here, they are entering service. Therefore, the parent company is engaged in manpower supply services. So these people are aghast. They said, if I am Boeing, if I am Hyundai, I am not a manpower supplier. I am a large multinational. You can't treat me as a manpower supplier. So the secondment employee was there. So we have said that, look, if he's employed in India on a 5-year term, 3-year term, he pays taxes to the Indian government. He's employed by the Indian company. He only retains his lien with the foreign company for social security purposes. For technically, he's still a Hyundai employee in Korea, but he's also working here. Now, despite multiple representations, the government still insists that these people must be taxed at 18% on the ground that it amounts to manpower consultancy services. These are small issues which irritate the investors and put them off completely. How much tax are you going to collect out of this item? So, in the short time that I've had, I've highlighted the various issues. Now, I come to the role of the All India Federation of Taxpayers. I want to make some suggestions. I am currently the part of the Tamil Nadu Advisory Council on GST and Fiscal Federalism. We have a team of lawyers, we have chartered accountants, we have software representatives, MSME representatives, large representatives. We have been repeatedly asking the people, please give us suggestions which we can put to the GST Council. Now, what we want to clarify is that one point we're working on is rate rationalization. And I'll just give a small example, just as a kind of an aside, how complicated the case is. Take a simple chocolate cake. If the chocolate cake is sold as a cake, it is liable to 18% because it is supply of goods. If it is sold in a restaurant where the rooms are less than 7,500, the rate is 5%. In the same hotel, if there is a banquet hall, the chocolate cake is subject to 18%. If the hotel has got rooms charging more than 7,500, the same product is 18%. So one restaurant owner in Tamil Nadu said that if he is selling 14 items on his vegetarian menu, they are subject to 4 different types of taxes. So we have been repeatedly requesting people, please give us examples for rate rationalization we can put. Now I come to the role of the All India Federation of Tax Practitioners, and I would request Mr. Samir Jani and other people to take it as part of your Golden Jubilee program. I would request you to have a committee, say a reform committee or a tax, reform committee is a simple word, both for direct taxes and indirect taxes. You have a membership of 11,000. All of you are interacting daily with tax problems of your clients. You know what are the pain points, what are the areas where the law can be reformed. And I would suggest that if you can have a quarterly meeting or a half-yearly meeting, get inputs from all the people from different regions and make a compilation and give it to the ministry concerned or the department concerned that these are the areas where amendment can be done. And from my experience in Tamil Nadu, they say we just don't want complaints. We don't want to say system is bad, things are bad. They want concrete suggestions. And all fairness to the government, many suggestions are also genuinely taken into account. So I would suggest that whatever problems the clients face, if you can, because the client can articulate it, you will be the best persons to put forth the problems. And from what feedback we have got so far from the ministry and also this is that they want actual examples. If you feel this rule is bad, what should be the drafted amended rule which you would like? Don't simply say this rule is bad, unworkable, it's arbitrary, Article 14, that's not necessary. You say if Section 17.5 is not correct, what should be the actual 17.5? So this will be a great role all of you can play. Having seminars is good, having discussions is good, but ultimately what are the action points? What are the concrete way forward that we take? And unless we do that, then these symposia, etc. have no meaning. So I would suggest to Mr. Jani, as part of your team, please form these committees and focus on areas which are going to do. And believe me, they do act. We recommended that don't have a 10-year reopening for various reasons. That has been accepted. It has become 5 years. We suggested that don't have multiple charitable trusts, 1023 for education, 215 for normal. That also has been accepted. So there is definitely hope and there is good response from the government if you make concrete suggestions. There is no point simply complaining and criticizing. Let us be the movers and shakers of the change that we want, and your federation can play the best role in this particular regard. And I'll finally conclude. I'll just finally conclude by saying that unless we change our tax system, nothing will change. I am now finishing 45 years at the bar. The same problem continues. You take Kanga and Palkhiwala. What Mr. Palkhiwala was lamenting in 1970, I am singing the same song today. So unless we completely transform ourselves, we will not get into the big league of the industry. We can have so many lectures and we can beat ourselves happy that this is very good and that's very good. But the ground reality, things are not good. I don't know if you know that the number of entities in India which have more than 5 employees is just 5 lakhs. Only 5 lakh entities have more than 5 people employed. That is the harsh reality. The biggest problem in the country today is unemployment and manufacture, and I'll conclude with that. In 2014, the manufacturing percentage of GDP was 16%. In China, it is 29%. So we said we should have a healthy benchmark that at least 25% of our GDP should come from manufacturing. It was 16.2% in 2014. In 2024, it has gone down to 13.9%. It has slid down. In 2014, they said they'll create 125 million jobs in 5 years. It actually, the reverse has happened. It has not happened. COVID is there, but otherwise also. So what I'm saying is, at the heart of the problem, the core issue to be addressed if India has to prosper is to have a completely new tax policy. As they say, unless there is death, there is no rebirth. We should now realize that if after 24 years, only 7 companies of India are in the Fortune 500, there is something seriously wrong with our system. We have to improve. And I'll just simply end by saying that we must, as tax professionals, I'm not saying because I'm speaking at a seminar, but I genuinely believe that once you alter the tax system, once you focus on growth maximization, India will be a far greater and more prosperous country. And one more thing, what I find is we are creatures of habit. Recently, Mr. Joshi was mentioning, in fact, I must just mention that I'm happy to meet him after 20 years. When I wrote the book Courtroom Genius, we had to interview people who worked with Mr. Palkhiwala. And I was sitting with Mr. Behram Palkhiwala, Palkhiwala's and Nani Palkhiwala's younger brother, and he gave me a list of people who had worked with Palkhiwala. And Mr. Joshi's name was there. He said, in say Milo, he used to brief Mr. Palkhiwala in sales tax matters. And I had interviewed him, so I don't know if you remember that. I still got your tape recorded interview. I interviewed him, and it's also, his name is also in the book. So it was a pleasant surprise to see him also here on his 91st birthday. So I wish you all the very best. So I would suggest, as I mentioned, start as reform committee, become the harbingers of change, and I'm sure that with this determination and the leadership of the entire All India Federation, we will grow to greater heights. I wish you all Merry Christmas and a Happy New Year, and let us hope that after 25, we really have lots of Achhe Din. Thank you.
Thank you so much, sir. We hope the legislature will soon come up with the reforms which you have pinpointed very well. And now I would request Shri Anil R. Dave, sir, for his comments.
My dear brother judges, friends of my legal fraternity, ladies and gentlemen, I think as a judge of the Supreme Court, I was very happy because if my colleague just says something very nicely in a judgment, I had to simply say, I agree or I respectfully agree. Matter ends. I had not to do anything further. So had I been a judge sitting with my friend, Mr. Arvind Datar, after his lecture, if I had to say something, I said, I respectfully agree. That's all, and I have to go and sit. But Samir Bhai told me that if you do like this, you will not get the lunch. So there is always a price tag. Say, I have to say something. But honestly speaking, after such a